Now we're going to talk about separating substance from procedure for purposes of the Erie Doctrine. When a federal procedural statute or one of the federal rules of civil procedure is in true conflict with state substantive law, you will generally apply the federal statute or federal rule and not the state substantive law. Even though we said before that state substantive law is generally going to govern, the exception is where there's a conflict, the federal rule is going to govern. So for example, if state law imposes rules relating to service of process, that is the mechanism by which you inform the defendant that he has to appear in court, and we're going to discuss that later, that differ from the federal rules. Again, state rules relating to process differ from federal rules relating to process. The federal rules we're going to govern even if the rules relating to service are deemed to be substantive for the purposes of the underlying case, and even if the choice of federal or state law will determine the outcome of the litigation, as it did in Hannah v. Plummer. When federal procedural statutes or rules are not in true conflict with state substantive law, you're going to apply both. That means you're going to apply the federal rule and the state rule. Because they're not in true conflict, you're able to do so. For example, Rule 3 of the federal rules say that all you have to do to initiate an action in court is to file a complaint. Under state law, let's say you're obligated to actually serve the complaint on the defendant prior to the statute of limitations running, that is the deadline by which you have to file, in order to avoid dismissal. Both the federal and state rules are going to apply. Why is that? Aren't they in conflict? Well, no, because all the federal rule says is that the action starts when you file the complaint. This is important for certain procedural reasons, but will have little substantive impact on the case. The state law doesn't undermine the federal rule. The state law doesn't say that the proceeding doesn't start until you serve process. It doesn't undermine the federal rule that the proceeding starts when you file the complaint. All the state law says is that regardless of when the proceeding began, if you didn't serve the defendant on time, the case, which has been initiated, is now going to be dismissed. Now granted, that's a very fine line. How do you know when a federal procedural statute or rule is actually in conflict with state law? And more importantly, how do you know when something is substantive or procedural? That is the underlying state law. Whether it's substantive or procedural is going to be rather dispositive of the question. Neither question is actually quite easy to answer. It really just boils down to using your intuition. But as a practical matter, I wouldn't worry about it too much unless your professor makes a very big deal about this in his lectures during class, and your fact pattern on the exam gives you enough information to figure out what the state law is, what it actually says, and how it would be applied given your facts. Otherwise, your default assumption should always be to apply the federal rule. The reason I said not to give it too much sweat is because, as a practical matter, these questions are really difficult for professors as well. There are no hard rules. There is no clear answer. Your professor's looking for you to make good arguments and make the best argument you can. If you think your question is inviting you to opine on whether a state law is substantive or procedural, and if substantive, whether there's a conflict, argue both sides of the issue. Explore whether the state law is really procedural or substantive. That is, make your best argument why it's procedural, make your best argument why it's substantive. Make a decision, describe what would happen, and go on. If the state law is procedural, the federal rules are always going to govern. Remember, that was the underlying principle in Erie. State substantive law governs, federal procedural law governs. If the state law was substantive, ask whether the state substantive law conflicts with federal law. If that is federal procedural law. Give your best explanation as to why it does, give your best explanation as to why it doesn't. Choose the answer that makes the most sense for you, defend it as best you can, and move on.